The problem is that states are out of money, and as more and more business moves to the internet and moves to the cloud, the states estimate that they're losing somewhere around $23 billion worth of sales tax revenue. In New York in particular, they've come up with some very interesting techniques of trying to establish that businesses that you might not think would be taxable are suddenly taxable when they're doing business on the web. So one of the most common misconceptions about cloud-based computing is that the location of the server has some relevance in taxation. What is relevant is where is the information being reviewed, where is the person interfacing with the software. There's a lot of businesses that should care, whether they know it or not, should care deeply about New York's rules with respect to sales taxation of web-based products, because New York imposes tax whenever the end user is in New York. So if you're a business in New Jersey, in Connecticut, or California, if you've got New York customers, you may care about New York sales tax rules. The stakes for non-compliance can be extremely significant. The sales taxes could creep into the millions of dollars, and even though they're not collected, they're still considered trust funds. And that means they're not dischargeable in bankruptcy, but most importantly, it means that officers of the business, the CFO, the president, people who sign the tax returns or sign checks, they can be personally liable for the uncollected sales taxes. And without the ability to even go bankrupt, people who own these businesses could lose their homes if they don't follow the sales tax collection rules. The way a state like New York can impose sales tax is by looking at an internet transaction in a number of ways. Number one, they look at what the end user is getting. If the end user is getting a software interface, then New York will say that in effect, you've rented or leased or licensed software. Adobe, the company that makes the Photoshop software, used to sell Photoshop software for about, I think, $900. And so you would buy the canned software, you'd put it on your computer, and New York would tax canned software. Well, Adobe decided to have a web interface because not everybody wants to spend $900 on a piece of software. For only, $10, $20, $50, I can use it on my one photo. New York says that that is no different than buying canned software. Or if information is being provided to a customer, New York has a tax on information services. If I were to sell you a photograph or a CD or a video, and I were to hand that to you, well, that would be subject to sales tax in New York because I'm selling you tangible personal property. Well, what if I were to take that photograph, or take that music, or take that video and digitize it, send it through the internet, and there's no tax whatsoever? And that's become a real great planning opportunity for lots of businesses, especially photographers. It explains why when you go to iTunes, you don't pay sales tax, but if you go to the local music store, you do. Ways that you can ameliorate the impact of a past liability is one, through a voluntary disclosure. In New York, for example, even though you should have been collecting sales taxes for the past 20 years, if you come forward voluntarily before there's an audit, before you've got a gun to your head, most times New York will agree to only go back 3 years, to eliminate all penalties, to agree not to pursue any criminal liability, and they'll even reduce the interest rate. Currently in New York State, the sales tax interest rate is, believe it or not, 14.5%. New York will reduce it to around 7%. I'm Mark Klein, a partner at the law firm of Hodgson Russ, and I specialize in state and local taxation.